and litigators. And so we like to think that we can cover the entire IPR lifespan. So from initial invention through to drafting applications for you, prosecuting them, getting them granted, and then litigating those patents and trademarks and rights after grant. Whereas say we are one of the largest firms in the country, and we have several offices spread across the UK and Europe. A little bit about me. My name is Chris Hall. I have scarily 20 years working with telecoms companies to protect innovation in hardware and signaling at really all network layers. So that's layers 1, 2, 3, signaling in RAN, cover the application layer, core network, done some work in optical networking and the components for that. I have also been prosecuted numerous patents which have been deemed essential to the 3G, 4G, and 5G standards. I will say especially 4G and 5G. 3G was a little bit before my time. Increasingly now, I'm working on innovations for the upcoming 6G system. I believe that the intention there is that the first release of 6G will come out some point in 2028. So watch this space for that. And I actually lead the telecoms team at HLK, which is one of the largest and I think best in Europe. Okay, so what are we going to cover today? Well, what SMEs need to know about telecoms and SEPs. We're not going to cover everything. I don't have enough time to do that, unfortunately. But we're going to try and cover the basics as far as possible. So starting at quite a basic level, we're just going to see what the different types of IPR are, what the different types of IP rights there are, focusing especially on patents, of course. We're going to recap a couple of slides on how standards are developed. So that will look back a little bit on some of the things that Tony from Raycastle was saying in the first two webinars. And then we're going to put them together. So IP rights and standards, we'll look at standard essential patents and try and think of some ways that if you want to be a standard essential patent holder, how you might give yourself the best opportunity for doing that. At that point, we're going to swap over to the other side and consider if you're a standards implementer, if you want to implement a standard in your product or your business in some way, what do you need to think about for that in a sort of a frequently asked questions style. So we'll start off looking at the FRAND commitment. You might have heard that mentioned in the past. We're looking at a little bit more detail. We'll think about infringement bites and particularly where it bites. We'll get on to patent pools as well. It's a useful tool that you might be able to use in the future. And then if we have time, we'll have a very quick look at the future, which, as the title there might suggest, might be a bit more regulated than it currently is. And then hopefully we'll have some time to circle back and get some take-home messages for you to go home with. Okay, so without further ado, the different types of IP rights. Now, this is a very pretty graphic. I'm not sure why it's represented as a cycle. I didn't come up with it, but it looks pretty and it's a useful tool to go through the different types of IP rights. So starting at the top, you have trademarks. Now these are some means of identifying and distinguishing the goods and services of one business from those of another. So one of the examples would be word marks, so brand names, and logos. But it's a bit broader than that. Sounds and smells can also be registered as trademarks. If you hear the Intel bong, do 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 do, that is a registered trademark, a sound mark for Intel. Moving around the cycle, we have designs. Now, these protect the shape and form of a product. Basically, what it looks like, not what it does. So we're just considering at the moment what that product looks like, but it doesn't actually have to be a physical object. It can be a software object. So user interfaces in the field of telecoms can be subject to registration as a design. Bear in mind, you're only protecting what that looks like and not how it works, though. Patents we'll come to in a bit more detail, but essentially these cover inventions, processes, products, how they work. Trade secrets, somewhat similar to patents, but this time instead of publishing them as you do with a patent, you keep them secret within your company, and you actually have to take active steps to ensure that secrecy. Not relevant for this talk. Copyright, that covers literary, musical, dramatic, artistic works. In the context of telecoms, though, it doesn't have to be wonderfully beautiful literary works. It could be things like computer code. It could be things like instructional manuals and the like. So that actually is relevant. And then finally, we have domain names, which, yeah, you know what they are. Okay, so standards are typically concerned with how something works. So in the context of telecoms, that often means how two entities interact. So remember, the purpose of telecom standards is to provide rules which govern the behavior and interaction of different devices so that different products from different manufacturers can interact with each other in a predictable way. So a patent protects technical inventions, how something works. So that's the IP right that is going to be most applicable to standards, and that's what we're going to concentrate on. It's often thought of as the most powerful form of IP, as it isn't, or shouldn't be at least, limited by irrelevant detail. A patent protects a concept, not necessarily the specific implementation of that concept. So a way of thinking about this might be to contrast it with copyright. So if you have some computer code, copyright will subsist in that computer code, but it's much more limited to the particular code that you have written and not necessarily what that code does. So if someone else were to recode that code, recode an invention in a different way, they would not infringe the copyright. Now, if you had a patent on what that code does, that's much more powerful. It doesn't matter whether they recode it in a different way. If they are forming the same function that you have patented, they're caught by the patent, they infringe the patent. So it's a powerful form of IP. They're territorial, so you can use a patent to stop others from making, using, selling, all those, that long list there, an invention within a particular territory where you have the patent right, not elsewhere. It's an item of property, so you can sell it, you can mortgage it as you can with any other item of property. Importantly, in the context of this talk, you can license it for a fee, so you can allow others to use your invention in exchange for some fee, some royalty fee. It's also thought considered to be a negative property right. So it gives you the right to prevent others from exploiting an invention if you have a granted patent. But that doesn't give you the right to actually use it because your patented product might still infringe other people's patents. It's a negative right, not a positive one. Okay, last basic slide on patents. So they are granted for inventions which there's four criteria to be able to get a patent. They're granted for inventions which are new. So that means that they're different from everything which is publicly available at the time you filed your patent application. That is collectively called the prior art, everything that was known in public when you filed your patent application. They also have to be to possess an inventive step. So this is the patent law's way of saying they're not obvious. They've got to be new and they can't be obvious over everything that was in the prior art at the time you filed your patent application. The third one is an easy one to get around. They have to be industrially applicable. So basically, they shouldn't violate established scientific laws. The classic example is perpetual motion machine. You can't get a patent for that because it violates established thermodynamic principles. And then finally, they can't be excluded. So patent law sets out various areas of subject matter which are excluded from patentability. The most well-known one of those, I think, is business methods. You also have things like mathematical methods. And then software is a more contentious area of excluded subject matter. I don't want to get into it in huge detail, but basically, if you have software for doing something patentable, then the software is itself patentable. If you have software for doing something not patentable, so if you have something software for performing a business method, say, then that software is not patentable either. So software is actually patentable. It just depends what function it's performing. So to circle back then to that first requirement there, patents are granted for inventions which are new. The take-home point there is that you have to file a patent application before you disclose your invention publicly. So make sure you've got your application on file before you tell anyone about it. If you absolutely have to tell somebody about it before you file the patent application, make sure you tell them under a non-disclosure agreement or some other secrecy confidentiality agreement. Okay. Now we're going to circle back slightly to last week's webinar by Tony Wakefield. That was patents. Now we're going to talk about different types of standardization. So just going to recap very briefly, there are three types of standardization. The first is a dominant design. So the example here is Windows. We're not dominant anymore. Maybe it still is. But it was certainly dominant 30 years ago in the 90s. That was the only operating system available into the mass market, in my recollection anyway. So it's a de facto standard. It's sort of the only option available. The second one is formal standardization. So if you have standard development organizations, SDOs, whose job it is, whose whole remit is to come up with standards, that's obviously another form of standardization. And the example here we have is ETSI. And then the third type of standardization is in fora, consortia. So you have a group of companies, like-minded companies, who get together and decide that they want to form a standard and sort of agree it between themselves, and then possibly, hopefully, release that to the wider market. So we're primarily concerned with the second two shown here, and actually, really, the middle one is the most important for this particular talk. So looking at that one in a little bit more detail, how are standards developed? We're going to take 3GPP as an example, obviously closely related to ETSI. So this is just a graphic which shows the process by which an initial invention or initial idea concept can go into a standard and eventually be put out as an implementable standard in deployed devices and systems. So the first stage here, looking at towards the left of the diagram, actually is outside 3GPP. So companies work on their own or as part of groups to develop new concepts and ideas. So for example, some new technology might come in with a host of improvements in terms of energy usage or data rates. So this stage generates concept contributions. So these are usually very high level concepts, which are submitted for consideration to 3GPP. In the second stage, 3GPP, that is the group of companies and their technical experts that form 3GPP, considers those concept contributions and approves them for further research, but within the 3GPP umbrella. Of course, they may not approve them, and in which case those concepts are not included in the standard. But here we assume that there's a big tick and the concept is pushed forward. In the third stage, you have a feasibility study item. So basically that looks at the different ways in which that concept might be implemented. Usually the views of everyone of different companies will be canvassed, and everyone might have their own idea as to how to do it. And then the result of that, the output, is a technical report which summarizes those different ideas, perhaps provides a recommendation as to which is the preferred one. And that's in a technical report. In the fourth stage, there's usually multiple rounds of meetings, which really decide the nitty-gritty of how that concept should be codified in the standard in a very low level of detail. High level of detail? Very detailed specification. So this stage generates detailed technical specifications which cover and describe the different aspects of the 3GPP system. So, and they all interrelate to each other. So note that a change to one technical specification will likely entail changes to other technical specifications for consistency. So, and really throughout that process, you have these things. The top called technical contributions, where the various companies or groups of companies within the 3GPP submit what they think the answers should be to all of these things. So you have an iterative process in which each stage increases the level of detail and specificity. Inventions, including those which are eventually essential to the standard, can happen at any point of these stages, any stage. So they might be a very high level conceptual invention, or they might be in the detailed signaling of the technical specs. So, you might even have at the very last stage, an invention might reside in identifying a problem with the standard and then fixing it. As long as that problem isn't obvious, or as the solution isn't obvious, that's potentially patentable. So finally, standard essential patents. We need to come to the combination of standards and patents. So what is a standard essential patent, and how do you get one? Well, at a very basic level, you need a patent. That is not a patent application. So when you file a patent application, it goes through a process of examination. A patent examiner will look at it and decide whether or not your invention is worthy of a patent or not. And if so, then they will grant a patent. So you must have a granted patent, and that patent must be in force. So after grant, you will have to pay maintenance fees to the various patent offices where you have it in force. And so bottom line is you need to have a granted and in force patent. And then the next part is quite simple as well. At least one claim of that patent must be essential to implementation of a standard. Now, obviously, the standard is made up of lots of different technical spec documents. So it is permitted to combine those when you're trying to read a claim onto the standard. It's the combination of those. It's perfectly feasible to do that, provided that those technical specs all belong to the same release. So release 17 or 18 of the 3GPP standard, for example. You can combine those when reading on because different parts of the system will be described in different technical specifications. There's also some case law to suggest that a claim might read onto a part of the standard which is actually optional. So the standard can have mandatory parts and it can have optional parts which needn't be implemented in a particular commercial deployment. There's actually case law which suggests that a claim reading onto even an optional part is still essential, even if that optional part isn't implemented in the commercial network. But you should bear in mind that will be decided by a judge after lots of expensive litigation. So definitely a grey area. But I think the point for SEP holders is you have to be really careful with what your claim says and look at it quite robustly. Be critical of what the claim says, and communicate with your patent attorneys to make sure that you really understand it. So I've got an example here, which I have totally made up, but it kind of illustrates the point. So if the standard was to say, upon detection of radio link failure, the UE, so that's a user equipment, mobile phone basically, will perform cell reselection and attempt random access. And now let's assume for the present purposes that that's all it says. It doesn't tell you how to do random access, doesn't tell you what to do with it. If your claim says almost word for word the same thing, so upon detection of radio link failure, the UE will perform cell reselection and attempt random access to the nearest cell, It's provided an extra step, an extra thing. So if the standard doesn't say that the random access is done to the nearest cell, then that claim, which does say that, is not essential. It's not a standard essential patent. Even if in 95% of the cases, um, a UE following the standard will attempt random access to the nearest cell. If the standard doesn't mandate it, doesn't say that it will, then your claim is not essential. So you have to be really critical, think carefully about it, and make sure you've got uh, uh, a a claim that reads onto the standard closely. So tips for the would-be SEP holder. I said before, make sure you file an application before you disclose the invention publicly. Now, note also that your invention won't be standard essential when you file it because the standard hasn't been agreed yet. So you need to keep the claims as broad as possible at an early stage. So file your invention with nice broad claims that cover as many directions and implementations as possible that you can think of. It's far, far easier during prosecution of your application while it's being examined by examiners to narrow the claim scope, to add extra features in, narrow that claim scope, than it is to broaden it out. So make sure you start broad and cover as much as possible at the start. Try to think of all possible ways your invention might be implemented, and bear in mind that the standard may be fixed 3 years after you file your application in a way that you didn't even think of. If you've drafted the claims broadly enough, you still might catch it. Then you want to prosecute the application slowly until the standard is agreed and fixed. So tortoise. There are lots of ways to slow down prosecution, request extensions, pay fees at the last possible moment, that kind of thing. And then the standard is agreed and fixed. And at that point, you become the hare. So you need to narrow the claims quickly to read onto the agreed standard. It doesn't matter that at that point, if your claim scope is very narrow, you've got a lot of detail in your claim, as long as it's all in the standard, you have a standard essential patent. So you actually benefit then from narrowing the claim scope. So that's the idea. So get an early start, set your alarm, file the application early with broad claims, be the tortoise while the standard is being developed. Once the standard has been agreed, be the hare, act fast, reduce the claim scope, and hopefully get a granted patent quite quickly. Okay, so we're going to move on there from now to look at more broadly at SEP ownership, and particularly this is the ownership of patent families which have been declared essential to 3GPP 5G standards. This information is actually 4 years old, but it illustrates the point, I think. If you add up all of the percentages there, you get to 97% of declared patent ownership. So the vast majority of declared standard essential patents is concentrated within just 22 companies. Now, the scary thing is that these percentages are relative. If you were to look at the actual numbers of patent applications that have been declared essential, you would get to tens of thousands of patents and patent applications. It's a huge number, right? Now, note that these are self-declared essential patents. So, for example, Qualcomm has declared that many patents itself to be essential to the 5G standard, but no one has checked that. No one's checked the veracity of those claims. And actually, that's true of all of these companies. It's self-declared. So are they all really essential to the standards? Almost certainly not. Some studies have tried to estimate this because there are so many applications, you can't possibly tell, you can't possibly analyze them all, but you can choose a select few and then extrapolate. And they mostly find that less than half of the patents which have been self-declared as essential actually are essential. But nonetheless, there still are lots of patents which are therefore essential. You know, less than half of tens of thousands of applications is still tens of thousands of patents which are essential to the standard. So that's each of those patents is a negative right that can stop you from using the standard. So As an implementer, if you want to implement a standard, how do you find your way through that thicket? Health warning, this might be a slightly scary slide for those of you on the call who are implementing a standard or who are planning to implement a standard. So by implement, I mean you or your company is making or selling a product that incorporates an existing standard such as a 3GPP cellular standard, IoT, that kind of thing. Okay, first question. My product uses a standard. Does it infringe literally thousands of patents? Yes, yes, it does. Sorry, that is bad news. Arg, do I need to get licenses from all those SEP holders? Um, Unfortunately, the answer there is actually also within reason. Yes, you should get patent licenses from all of those holders, but you do have some advantages, which we'll get to. So one advantage you have is that those companies who contribute to a standard must make what's called a FRAND declaration. So that is, they commit to license their standard essential patents and other IP to anybody and everybody on fair, reasonable, and non-discriminatory terms. So remember also that SEP holders, they have a vested interest in the success of their standard. They want it to succeed. They want it to be widely adopted because that's going to increase their revenue in terms of license fees. They typically don't want to stop companies from using the standard. So as long as those companies are willing to pay a license fee, then they are very happy for that to happen. So what does FRAND mean? It's incredibly complicated. Wars have been fought, it feels like, over FRAND, certainly in the courts. But we'll just go over it very quickly. So the F stands for fair, reasonable, non-discriminatory. So fair license terms. You cannot have anti-competitive or unlawful license terms in your FRAND license. So if an SEP holder was to say, yeah, we'll grant you a license, but you have to buy our product, or you can't use that company's products, that's an unfair license term. It's anti-competitive. Reasonable. This is the real difficult one. There's no clear definition of what a reasonable royalty rate is. And I don't know what one is either. The courts usually decide, but it may include reference to aggregate royalty rates. So if you added up all of the royalties that would be payable, if every SEP holder charged the same rate, is that aggregate rate reasonable or not? Discuss. There's a lot to unpack there, but we don't have time today, unfortunately. And non-discriminatory. So that just means that licensees are treated in a similar manner. It doesn't mean that you will get the same rate as everybody else. You can take into account different commercial realities. So I don't know if there's a company that's willing to pay its royalty fees very quickly, or willing to pay, has a huge volume, then they can expect a different rate compared to a company that has a smaller volume or wants to pay slowly. Okay, so the next thought you might have as an implementer is, well, hang on, who infringes? Where does patent infringement bite? So there's a principle called patent exhaustion, and that does apply to patent infringement. So that basically means that the same patent cannot be enforced multiple times for the same infringement. Let's consider a practical example of that in the field of telecoms. You've got a mobile phone manufacturer. They design and sell phones. They do not design and manufacture chips. They buy those in from other companies, including a telecoms chip, which provides necessary functionality for that phone to use a telecom standard like the 4G or 5G standards. Who infringes the SEPs? Is it the mobile phone manufacturer? Is it the company that produces the chip? Answer, they both do. They both infringe the patent. Okay, but then who is liable to pay the license fees? to the SEP holders? Is it the phone manufacturer? Is it the component manufacturer? This one's a little bit less black and white, but the answer is typically the end product manufacturer. Okay, so in this example, it would actually be the phone manufacturer. This can actually vary a little bit depending on the industry, and also just where the SEP holder chooses to bring an infringement claim. But they would typically do that against an end product manufacturer. Now, a final word of warning here. I have heard several times people saying, well, hang on, the contract with my component manufacturer says that they're going to take care of that. They've got the necessary license fees from the SEP holders. So I'm taking them at their word. That's fine. We've got a contract. And if I get sued for patent infringement, I'll just hand it over to the component manufacturer. It's their problem to deal with. And actually, this came up in a recent news story by an SEP holder who sort of called it out and said, well, we've seen some contract terms from a chip manufacturer which says supplier respects the importance of IPR and respects laws and regulations. As such, supplier is actively engaged with known essential IP owners and successfully secured licensing to legally use their technologies in this product. So you think, great, wonderful, they've got it covered. The issue, of course, in that case was that the SEP holder said, that supplier has never once spoken to us. That's just, that promise on that contract is not worth anything. And so they can still sue the eventual product manufacturer. And even if you were to say, well, hang on, I've got a contract with that component manufacturer, I've got an indemnity, you need to remember that will only allow you to recover your damages after you've already been sued by an SEP holder. So as an end product manufacturer, you could be sued for infringement of SEPs and be found liable for damages. And then if you want to get your money back, you then have to sue the component manufacturer. So that is costly litigation on top of costly litigation. You do not want to be in that position. So in order to do that, do your due diligence. Have you actively, you should ask the questions, right? Don't just take their word for it in a contract. Ask questions. Have you actively engaged with IPR owners? What licenses have you obtained? From whom? Be specific. Don't just take their word for it. Okay, so you're left with a complicated picture. This is an example where we have a schematic illustration of there are 5 different patent holders, P1, P2, P3, P4, P5. And in this example, there are two licensees, two implementers who would like to get patents, who would like to get licenses to the patents to use a standard. Of course, in order to use the standard without infringing IP rights, each of these implementers needs separate licenses from each patent holder. And of course, I've illustrated 5 here, but an earlier slide showed there were 22 for 5G, and it's probably in fact more than that now. So as an implementer, that's a horribly complicated picture. You don't want to be involved in getting licenses from that many companies. But bear in mind also that the picture is complicated for SEP holders too. So, I mean, according to this model, they have to negotiate licenses with each SEP implementer, and that's not only time consuming for them, it might even be sensible for them commercially because the rate of return just isn't worth it on each particular license. So there is another way. So one solution to this is the patent pool. So according to this model, multiple SEP holders pool their patents and then outsource licensing of that pool to an intermediary administrator, patent pool administrator. So, if you are an SEP, an implementer, you would like some licenses, then you need only go to the patent pool administrator and agree a single license with them. and that grants you a license to use all the patents in the patent pool belonging to all P1, P2, P3, P4, and P5. So as part of that license, you'll pay royalty fees, but you pay them to the patent pool administrator. And it's their job then to divide those up between the different rights holders according to whatever agreement they have with them. There are multiple advantages to this. You're saving considerable time and cost, both for implementers and also SEP holders. You don't have to negotiate multiple licenses, but a single license with the patent pool administrator. Also, the license is often quite standard or simple terms. So upfront, as an implementer, you'll know the cost of doing business. You know, they'll say it's going to be this much per device or whatever. Patent pools often cover a very large number of the SEPs required to implement a standard, but the disadvantage is they may not include all the SEPs required to implement the standard. So just because you have a license to a patent pool for a particular technology, it doesn't guarantee that you have all the necessary SEPs in place. It just reduces the risk. Okay. So it's a significant advantage, but it's not a guarantee safe harbor. Here are some example patent pools. So Sysvel, they have various different pools. As you can listed there, Avanci, similar. They have more of a vehicle slant to them. VIA recently merged with the MPEG Licensing Alliance. So they cover things like audio and video, also wireless charging, and which is relevant to your business depends on the standards you want to implement and also the products that you want to implement them in. It's a commercial decision for you as an implementer to decide on the best patent pool. Things to take into account: what license fees are you going to pay? What coverage do you get? So what percentage of standard essential patents does the pool claim to include? What are their license terms? Do they place restrictions on how you can use or implement the standard? So patent pools are a really useful tool. Now, off the record, I don't have a slide for this next part. There is a commercial reality to all of this, okay? SEP holders are very unlikely to come knocking on your door for a license when you're just starting out. So if you're an SME, the amount of royalties you're going to generate for a patent holder mean it's going to be so low that it's just not likely to be worth their time in negotiating a license with you. Okay, so at an early stage, you probably don't need to worry too much about that. But obviously, you want to grow, you want to become successful, and at some point, that balance of convenience will change. So they will come knocking, they will demand a license because you're now making enough money that you're visible to them and that it's worth their time to get license fees out of you. So take home for implementers, know that, and at some point, if you're implementing a standard and you're successful, you will need to pay license fees to SEP holders. Have a plan for that moment. When it happens, are you going to use a patent pool? If so, which one? How much will it cost? How are you going to cover that cost? You're going to keep your prices high? You're going to increase them? How are you going to do that? If you won't or can't use a patent pool, maybe there's no suitable pool which exists, how are you going to negotiate with SEP holders? What's your best guess as to the likely royalty rate across all of those? Build those costs into your business model at an early stage so you're not left panicking as and when patent rights holders come knocking at your door. Okay, last slide, substantively anyway. Just looking quickly at the future. So it looks like it's going to be more regulated, certainly in Europe at least. The European Parliament last year, about a year ago, approved regulation on standard essential patents. It's too much to go into here, but basically it was deemed to be rather pro-implementer, quite widely seen, because the majority of changes actually place additional burdens on SEP holders and not on implementers. So it's quite friendly, I think, to SMEs, also mega-rich implementers like Apple and Samsung. The major themes are um, establishment of a central electronic standard essential patent register, um, where patent holders have to register their patents in order to enforce them. So you have much more visibility as to which standards, so which SEPs relate to which standard. The EU IPO, so that's the European Union Intellectual Property Office, has jurisdiction to decide what the FRAND rate is. And also it will conduct essentiality checks. So the idea there is that they'll pick randomly at portfolios and decide for themselves whether they are essential or not, whether they belong on the register. This is slightly controversial because the EU IPO has no experience of patents whatsoever. It's a body which looks at the registration of trademarks and designs. So that's a bit controversial. This is not yet in force. The Council of the EU has to either agree to it or suggest changes as part of a negotiation with the Parliament. So it may yet change. It may never come into force, but it looks likely to change the environment in the coming years. And then quickly, some take-home messages. Hopefully, you've got some greater clarity on the interaction between patents and standards and the obligations which are placed on all parties, but especially standard essential patent holders. Some tips for those holders. Make sure you file your applications before you disclose your invention. File your application with broad claims and really slow the prosecution down. And then once the standard's been agreed, that's when you narrow the claim scope and really try to map onto the standard closely. And then the final sort of take-home message for standard implementers is just have a plan. Know how you're going to approach SEP licensing as and when it comes to you, because it likely will come to you. And so you need to know what you're going to do about it as and when. Okay. And with that, I'll see if there are any questions.
I've got one, Chris.
Yes.
Yeah, so it relates to the software aspect. So my background is actually in wireless communications,
Hmm.
and we have an open source software, but we modified it heavily, and we're looking for ways to exploit it commercially.
Okay.
However, the initial feelings that we're getting from the university TTOs, a commercialization team, is that especially in the UK, it's challenging to protect a piece of code. So any suggestions, any
Um, so first of all, open source is its own topic. So I'm not an expert in open source, but it sets alarm bells off in my head that there are risks associated with using open source and modifying it. In
yeah,
terms of patenting software, don't go into it in this call, but it really depends on what the software does. Um, so if your software is I don't know, if it is controlling an entity outside the computer, for example, then that's potentially patentable. Obviously, it needs to be doing that in a way that's new and inventive and all of the rest of it.
yeah,
But if it's controlling something outside a computer, then usually that is deemed patentable. Um, if it is making the computer itself run better, as a matter of fact, then often that's also deemed patentable. The example there was, I think there was a patent granted for really, I'm not a computer expert, but I think it was like the sort of the basic kernels that the computer itself functions on.
mhm,
Might have been a DLL library or something like that. Basically, there was an invention that improved that, and because the entire computer used that those software kernels, even though it was software, it improved the performance of the computer as a whole and therefore was deemed patentable. I mean, where the advice you got is correct is that the UK is probably one of the more hostile environments for software patents.
Mhm.
Um, uh, the case law has been interpreted quite narrowly here, so you would need to be quite confident that it was clear of those sorts of issues. But the UK is not the only place you can get a patent. If you want to commercialize your invention in Europe, in the US, for example, typically they're a bit more relaxed about um, patentability of
Mhm.
software. So it's not strictly relevant as to whether or not the UK is a harsh environment. It just depends whether if your market is entirely in the UK, then yeah, that's a tough thing. If your market is outside the UK, then well, you could get a useful patent outside the UK, um, possibly.
Mhm.
Um, yeah, if you want me to look into it in more detail, please message afterwards.
Thank you. Thank you very much.
Uh, oh yeah, I see Andy has commented on the open source licensing issue. Yeah, that's he says, have you checked what open source licenses the original code had? What you can do may be constrained by those licenses. That's absolutely true. They are, yeah, that's an important thing to take into account. Okay, so if there are no other questions, I will hand over to Andy Reid of UK Tin.
Hi, first of all, can people hear me okay?
Yes.
Uh, this really just a short bit to say that UK Tin, it'd been set up by the government to be a hub, a centre for telecoms industry, particularly wanting to uh, facilitate innovation to generate some growth in the sector within the UK, and particularly if you're a small company or even thinking of starting out a small company, we're here to help. And there's all sorts of different things that we can do, ranging from advice in seeking funding, in things like this where we can provide information, particularly if it's standards. That's one where I particularly am involved. Please do get in touch. We can talk one-on-one. There are three of us that are in a pool that cover quite a wide range of telecoms. That Howard Ben, Luis Lopez, whose background is more mobile, my background is more fixed internet, transport optics, network management, and those sorts of things. So hopefully we cover most of the questions you might have. Uh, IPR is not something that's immediately our particular expertise, but it is something that we have regularly encountered, so we can at least pass you or help you find the right advice in the right direction. So it's to say, please do feel that you can get in touch with us. I think on the next slide, hopefully you'll be able to get hold of this. There's a whole series of links here for all sorts of different bits of help. The main thing is, do go and investigate the UK Tin website, do sign up on the website. That will then give you access to all sorts of different bits of information. That it also includes, if you look at the third bullet down there, that's one that particularly that will get through to Howard, Luis, or myself. Do make use of this. We're here to help.
Okay, thanks, Andy. And thank you everyone for joining. I hope you found it useful. If you have any questions or feedback, please reach out to UK Tin on the email address provided. If you have any questions on IP specifically, please reach out to me. I'm Googleable, Chriswell at HLK. Yeah, thank you all for your time.
Thank you all.
Thanks, Chris. Thanks, Andy.